Hello, my name is Karin Ablin, and I'm a partner at the law firm of Fletcher, Hildreth. Our firm's practice focuses on representing media and telecommunications companies. My practice in particular focuses on assisting media and other companies with music licensing and other copyright law issues that may arise in their businesses. This video is part of a series of videos prepared for women in media to highlight issues that lawyers embarking on their legal careers may encounter as they provide legal advice to media companies. Previous videos covered how to approach content licensing questions generally and commercial radio licensing of musical works. In this video, we will cover non-commercial radio licensing of musical works. Remember, sound recordings require separate licenses where licenses are needed. The right for non-commercial broadcasters to perform musical works is subject to what is known as a statutory license. That term is just a fancy way of saying that Congress has taken away from copyright owners the right to say no if a non-commercial broadcaster would like to perform its works. If the parties cannot agree on a rate, those rates are set in 5-year cycles by a 3-judge panel that sits in Washington, D.C., called the Copyright Royalty Board. Rates were just agreed to for the upcoming 2023 to 2027 term. There are 3 separate categories of non-commercial broadcasters that are subject to different rates: stations affiliated with National Public Radio, stations affiliated with an accredited college or other educational institution, and all other non-commercial broadcasters, which largely consist of religious and community stations. Non-commercial broadcast musical work rates must be negotiated with 4 different entities, which are called performing rights organizations. They are ASCAP, BMI, CSAC, and Global Music Rights. These organizations negotiate and collect royalties from non-commercial broadcasters and then distribute those royalties to their affiliated copyright owners. Each of these organizations represents a unique set of musical works, so non-commercial broadcasters must obtain a license from each organization if they play music in that organization's repertory. Except for National Public Radio, the rates are annual flat fees that typically vary based on a station's music intensity and population count. For non-commercial webcasting, no statutory license applies. Instead, each station must obtain licenses from the performing rights organizations or the copyright owners directly. Religious broadcasters should consult the National Religious Broadcasters Non-Commercial Music License Committee, as that entity negotiates webcasting rates with these entities. I trust that you found this video helpful as you develop your media law practice. If you need more specific legal advice about a particular situation, feel free to contact me at ablin@fhhlaw.com or 703-812-0443. Thank you, and best wishes in your practice.